Hi, everybody. This is Elektra Yao, artist visa lawyer located in New York. I'm just trying to fix the live that I'm doing on Facebook as well. Um, anyway, I wanted to make this video because I have not been live in a while. The reason for this is because we've been working on a lot of cases. We've been helping lots of artists of different artistic disciplines, artists who are working, who maybe were denied previously with another lawyer, rush cases. So clients who entered on a tourist visa and are changed status. So we've been very busy. But I felt like, in light of the fact that the election is coming up and everybody being a little bit antsy, I felt like a live was due. And don't mind the background. I am one of those lawyers that reads a lot of books. You'll see my law book over here, my model book. We represent lots of models, but I wanted to come live and go back to the basics. What do you need to know about the artist visa? What are some insider tips and tricks to make this process more seamless and more accessible to you, to help you really understand what you need? Because a lot of the times when you are reading and embarking on this on your own, you're kind of getting tidbits of information from maybe your friends who went through this process. I got an email yesterday from someone's like, my friend did this. Um, that's fine, but what's important to know is that it's critical, if you want to be successful, to work with a licensed attorney who has lots of experience with O-1s. So what do you need to know about O-1 visas? What is something that is really important about O-1 visas? So first off, O-1s are bifurcated into two subsections: O-1Bs and O-1As. So I am known as the artist visa lawyer. I work almost exclusively with artists, but I also do file O-1As, right, which are for athletics and science and teaching, etc. However, I mostly work with O-1Bs, but we still have a lot of knowledge on O-1As and other visa types as well. But that's the first thing to know. They are divided into two separate categories, where the arts being one category, and then science, athletics, etc., being in a separate category. So that's the first thing that you should know. Probably the next question you're going to ask yourself is what box do I fit into? Do I fit into the artistic box, or do I fit into the business, science, athletics, teaching box? Now, that's a really important question, because the answer to that question is going to determine the strategy utilized in your case. And it also is going to determine the scope of work that you can do and the law that's going to govern you during your O-1 validity period. Now, I'll just open a little parentheses, right? That professional title that's going to determine whether you're O-1B or O-1A is very, very important. So, just to give you an example, all of my marketing specialists, we file them under the arts. So, my marketing, whether you do CEO, whether you do copywriting, whether you do social media, whether you do media strategy and you're not designing anything, I file these under O-1Bs, so under the arts prong. My architects, I file them under the artist prong. Other attorneys file them under O-1As. I think it's very, 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 very important to identify whether you use creativity, strategy, whether you are employing any sort of artistic discipline or artistic knowledge in order to identify whether or not you are working in something that is arts related. Because if it's not arts related, then it's going to go under O-1A, which is a higher legal standard. Now, it's very, very important. I think that I got cut off on Instagram. I don't know if you guys can see me. It's very, very, very important to identify the arts, whether or not you're using that. So that's the first thing to understand. Are you under the O-1B category, so arts, or O-1A? And as I said, that's a strategic and legal decision. I strongly recommend you speak with an attorney to kind of figure out whether or not this is something that you would fit into. So now that we've identified that there's two separate prongs that you fall into, what is the nitty gritty? Now, the first thing I want to do is I want to talk about these myths, right? These myths that are associated with the O-1s. A lot of people get afraid to file the O-1, or get apprehensive, or feel like they don't qualify because of these myths. So myth number one: you do not need an award. While it is great that you've won an award in your field and you've been recognized for the work that you have produced and executed in your field, it's not a requirement. It's great to have, but it is not a legal requirement. Number two, do you need to make high salary to work under O-1B to be an artist in the United States? Now, the answer is no, you do not. You do not need to be making $100,000 worth of work. Now, again, this is a legal and strategy question that has to do with your professional profile and also has to do with the way the forms are completed and how your contracts, your future contracts are drafted. Very critical that you work with a licensed, experienced O-1B attorney who can identify the nuances. So the second myth, you don't need a high salary. Third myth, you don't need to be famous. There's no famous requirement or fame requirement for the O-1. Yes, we do represent famous K-pop bands, J-pop bands, famous influencers, but that by no means is our only type of clientele. We also represent people who a year ago were just students or people who have never worked in the US. There's no requirement to be famous. Now, if you're famous, does that help? I'm not going to lie to you guys. Absolutely. Being famous in your field is definitely going to help, but it is not a legal requirement, nor is it a bar to you filing the O-1. So now that we've gotten these myths out of the way, there are a bunch of other myths, and we can talk about that in a separate video. But now that we've gotten the myths out of the way, let's talk about what do you actually need for the O-1? Like what is necessary for the O-1? Now, I'm going to invite you guys. I know this is really difficult to do when you're talking to a lawyer or when you're talking to an attorney. I know that it's really difficult to ask, like, do I qualify? Or what of my chances of success are? I want you to deconstruct the O-1 and work backwards. Now, instead of thinking how do I qualify, start to think about what you need, because what you need is going to lead you to qualifying for the O-1. Now, somebody asked a question. I'm going to respond to that really quickly before I get into what you actually need. So thanks, Advi Tavo. I hope I'm saying that correctly. What's the role of an agent? Can a self-employed musician apply? So this is a really tricky question because you're mixing a lot of language that you use in the real world with language that is not applicable to the O-1 world. So let's get your second question. Can a self-employed musician apply? Now, if what you mean to say is, can a musician who has different work opportunities, like working for a company, working for a gig, performing here, performing there, can you apply in the sense that you don't have a 9 to 5 job? Yeah, absolutely. You can definitely apply because there's no requirement to have a strict interpretation of employment. So I'm a lawyer. I'm at the office 9 to 5, right? That is a very strict interpretation of employment. That is not a requirement for the O-1. So can you, with multiple jobs and future engagements, which is actually the legal term, can you with multiple future engagements and multiple past engagements apply? Yeah, absolutely. There's nothing that prevents you from applying. Now, what is the role of an agent? Now, this is also a tricky question because the role of the agent is both a legal question and both an artistic question. Now, if you are a model, for example, or an actor, for example, and you have a talent agent or a talent manager who is getting you gigs and is like, yes, I'm going to get you gigs, but I'm also going to be your legal representative for your O-1 petition, then that means you're most likely paying that 10 to 15% to that talent manager. And that agent has that legal agent, once he or she signs the immigration forms, will become your legal representative, which means that he or she controls the petition. Now, if you're talking about agent strictly within the O-1 world, we are talking about somebody who is a US citizen, somebody who's a green card holder, or a US based company that is petitioning for you. So petitioning is just a legal term to say persuading. So persuading the government that you should be approved for the O-1 and that you, the agent, have control over that petition. So your best friend Becky, who's a biologist, who's a US citizen living in Brooklyn, she can serve as your agent. But if you're represented by Wilhelmina Models in Manhattan, that Wilhelmina models can also serve as your agent. So to answer your question, it really depends on the type of agent you envision for your petition. But if we're talking about agent in the strict sense, legal agent for O-1 purposes, really can be anybody that's going to persuade USCIS to approve you for the O-1B. So, what do you need for the O-1? So, the great thing about working with our law firm is that we've completely deconstructed this for you. So, we've deconstructed the major aspects of the O-1 in our client portal. And we've also identified all the different tasks associated with the O-1. There's about 150 tasks associated for the completion of a successful O-1 petition. Great. Now, what does this actually mean? So basically, it means that there are subcategories within the O-1. Great. I'm glad that that was helpful. Go on our website. There's a bunch of free resources that you can download, and I hope that that will help you in your O-1 journey. But basically, the O-1 in its deconstructed form is a bunch of macro categories, right? That's how I see it. I'm a very visual person. I'm also a linear learner. And I think that for this case type, which is labor intensive and paper heavy, you need to have a very strict organization. Otherwise, you, the client, are going to get lost. Now, these macro categories, this is what you need, the macro categories. So the first one is your forms, right? The forms is the technical application for the O-1. The form that we use for the O-1 is the form that's actually applicable for all temporary work visas. So you need the immigration forms. The immigration forms need to be properly drafted and signed by the attorney of record, so the attorney that's representing you, and by the agent if you're petitioning with the agent, or the employer if you're petitioning exclusively with the employer. Now, just so you know, licensed New York State attorneys, that's where I'm licensed, that's where I practice law. I cannot tell you which boxes to fill. That's malpractice. So no attorney that is strictly following the rules of ethics is going to be able to tell you, hey, you should check off A, B, and C. That's an ethical violation. We cannot do that because filling out the boxes or advising you to fill out the boxes is a form of, number one, legal strategy and legal work. But immigration forms is actually one of the macro categories to consider when you are architecting the petition. Now, the second macro category to consider is your future work. So I want to be very, very clear on this because a lot of times people are confused about that future work aspect of the O-1. Future work is the basis for identifying your O-1 validity period. So if you think of your O-1 validity period as like a continuum, right? As like a line in time, it has a very specific start date and a very specific end date, right? And that specific start date and that specific end date is going to be governed by the future contracts that you have. So it's going to be essentially governed by the people who have decided that they want to work with you. Now, future contracts needs to cover the 3-year span if you want 3 years. I can do a 1-month O-1 for you. I'm working on a 1-month O-1 right now. But the legal work that I'm doing for a 1 month is the same that I'm doing for a 3 year. So it's something to consider strategically in terms of your economic investment in the O-1. Of course, we will represent you the multiple times that you want to do your O-1. But in terms of really understanding your artistry as a business, I do not think that paying our law firm twice in a less than a 3-year period is the best use of your artistic funds if you really want of your money, if you really want to start to approach your artistic career with the proper business mindset. And I believe that this mindset is very important, especially if you have aspirations for the EB1A, which many of our clients do. Many of our clients, we filed their EB1A after their second O-1, and I'm proud to say that we have a 100% approval rate. But this is because their mindset changes once they become a client and once they start working with our law firm. So anyway, very important. Future work is necessary. That continuum of time is identified by your future work. If there are no future work contracts, so if there's no future engagements, if there's no work lined up for you, there's no basis for approval because there's no work in the future for you. So there's no need to have work authorization for the O-1. So future contracts And proof that you're going to be working in the future is an absolute necessity for the O-1. You can have the most beautiful profile. I can draft the most fabulous letters for you, but there's no basis for approval, so I cannot file your case. It would be a frivolous case. So that's number two. So number one, immigration forms. Number two, future contracts. Number three is your artistic portfolio, which is basically a fancy word of saying evidence. Now, I would caution all of you to go out after this call and start to draft your own portfolio. Very commendable, but you would be wasting a lot of your time because the portfolio has a very specific structure, because there's very specific things that we need to demonstrate and show USCIS. So what does this mean? This means that the portfolio is architected with intention. So the documents that are included within the portfolio have a purpose, right? We need to show USCIS very specific things about your artistic profile, because the truth of the matter is this is a visa with no cap. This is a visa that they don't want to approve. And this is a visa that gives you lots of professional freedom. So those three factors make it so these cases are, number one, highly scrutinized, and number two, unfortunately, they're discretionarily approved, which means that it's not like, oh, I've got letters, I've got a portfolio, I've got this and that, I'm definitely going to be approved. Absolutely not. It's discretionary, which means that we need to persuade them, hence the name petition. So you need your artistic portfolio, which is basically your evidence, which is proving that we are alleging what we are stating within the legal brief and within the letters of recommendation. So let's say, for example, you're an actor and I state, or we had somebody on the call who's a musician. So let's say I'm stating that you performed at CBGB's, right? You're like, hey, Elektra, I performed at CBGB's. And I'll be like, yeah, that's great. That's a historical, internationally recognized, historically relevant art venue, right? That's great. I'm going to believe you because most people are going to tell their lawyer, the truth. Now, that's great. Fine and dandy. I need to prove that. So I'm going to write the letter of recommendation, which confirms your leadership role of playing within a distinguished event and a distinguished venue. Fine and dandy. And I'm going to need the proof. So if you're like, hey, Elektra, I actually don't have proof. I don't have emails. I don't have a set list. I don't have rehearsal pictures. I don't have production pictures. I don't have flyers. I don't have marketing materials. I don't have social media posts promoting this performance. Well, that's going to make that aspect of your case, which is technically really strong. Performing at CBGB's is actually a huge achievement. It's going to make your case strategically deficient, right? Because legally, technically, I could just file with the letter of recommendation. They, number one, hate that and will give us pushback. And number two, like I said, I need to prove that you've done what you've actually said that you've done. So the letters of recommendation confirm what the evidence is stating. So I'm going to need the proof. So the proof can be a bunch of different things. And in our firm, we give you a list where we identify different types of evidence, right? What we call subjective evidence and objective evidence. And we can do a whole video on the difference between those two types of evidence. In addition, we give you the order, right? The order in which the document should be in. So this, again, is strategy and intention. So I personally believe, and this is how we execute our cases, everybody has beautiful final product pictures, right? A beautiful picture is not going to win the case. I believe in demonstrating to USCIS the nitty-gritty, the process, the time and effort that you utilize to create that work, because time and effort is going to distinguish you from other people. Let me give you an example. I represented successfully a client who retained our law firm for a 2-week case. So 2-week case basically means you retain the law firm on Monday and 2 weeks later your case is filed, right? We routinely do this, and we can talk about rush cases in a separate video, because I do not believe that you need 6 months to prepare an O-1 petition at all. Anyway, client had gone to a different attorney. This case had a very horrible RFE. This case, the petition that was submitted, was filled with beautiful pictures, right? Beautiful final product pictures, which I said everybody has. Think of it like Instagram. Everybody's got beautiful Instagram pictures. Very few people have the ability to show the behind the scenes of their work, right? Which is what is actually very interesting for somebody who is not of the field. Client got an RFE, client withdrew that case with the other attorney, came to us, hired us for a 2-week case. That case was approved in 2 days. Now, my approach to the portfolio, again, is very intentional and very strategic and very specific. There's a reason why the case got approved in 2 days, right? No RFE, approved in 2 days, premium processing, and that client is now able to work. And that client was not even a visual artist, which basically means I didn't have like beautiful final product pictures, right? I didn't have a painting to show. I had other things that I needed to show to prove the day-to-day of her work. But again, intention and strategy. And this is established by us during 2 meetings called a portfolio review. So in our portfolio review, I'm going to curate the portfolio. I'm going to say, this is great, this is bad, this is great, this is fantastic. So that's the third thing that you should have. So far we've discussed 3 macro categories. We've discussed immigration forms, future contracts, portfolio, and now we're going to discuss the infamous letters of recommendation. So the letters of recommendation, during consultations, clients are always like, oh my God, Elektra, I need 8 letters. Well, the great thing is the law does not say 8 letters. The law does not even give us a minimum or maximum number of forms of evidence that we can have. So the number 8 is a number that I got to based on years of experience, right? I've been representing artists. I myself was an artist before I became an attorney. This is the sweet spot. This is the number that I feel that is not excessive, but thoroughly exhaustive, which means that we give them 8 different letters drafted in different styles, drafted with different tones to showcase and confirm the artistic achievements that you have accomplished throughout your career. So do you need 8 letters? By law, you don't. Do I strongly suggest 8 letters if you're working with our law firm? Yeah, I do. I think that is a really important component of the case. Now, a lot of law firms are different. I'm sure you guys can understand that. There are law firms who don't draft 8 letters. There are law firms who do draft 8 letters, law firms who don't draft letters at all. These are legal documents, right? These are legal documents with legal assertions, right, that are speaking towards the federal regs. I strongly believe that the lawyer should draft them and they should be reviewed by the person signing to ensure proper tone, proper use of language, et cetera, et cetera. But letters of recommendation or testimonial letters, these are things that you need to include within your petition. So we draft the 8 letters based on a meeting that we have. We have something called a legal strategy session. And then you will review the letter for factual accuracy. And then the letter will be reviewed by the signer, endorsed by the signer with letterhead, logo, or whatever, and then signed by the signer. So these are your, I think, 5 macro categories that we discussed. This is essentially, the cliff notes of the O-1 artist visa. I hope that this was helpful. I'm going to go live every day. We are very busy right now, especially with the election, but I strongly believe that because of the election, it is important to kind of ensure that you have knowledge of what's going on in the O-1 world, especially because if there's a Republican presidency, there might be changes, just like there were previous changes to the O-1 with the previous presidency. So I'm going to go live every day until the election. Maybe if I have time, I'll go live actually on the election day and we can talk about it together because, again, this is something that affects everybody in the world, not only international talent coming to the US, but it also affects Americans who are living in the US because, of course, art has no borders, right? This is why the artist visa exists. Art has no borders and art has no boundaries. The US has a long history of welcoming and supporting international artists and supporting international artists, and Americans are very receptive to international artists and global talent because, again, I'm located in New York City. It's kind of a melting pot. There's everybody from everywhere here creating, doing amazing different things. So I'm going to go live every day. If you have specific requests or if you have things that you want me to talk about, just write it down in the comments, DM me, send me a message, and I'm happy to talk about it. I'm very passionate about artist visas. I represent artists almost exclusively. We have a handful of clients who are investors, who work in tech, but I represent almost exclusively artists. And I'm not specialized in any artistic discipline. We represent everyone from chefs to marketing experts to K-pop stars to influencers to actors. We represent all different artists. And I think the reason for that is because I have a background in the arts. I studied, theater for 10 years, and I have a film degree, and I worked in film and TV before going to law school and becoming an attorney. So I hope that this was helpful. Any specific topics, then DM me, send an email, send a message. But if not, I will see you tomorrow. Tomorrow I'm filing a bunch of cases. So it will be really cool. Maybe I'll show you the different sizes of the petitions. Tomorrow I'm filing a graphic designer, an actor, an architectural designer, and one more other artistic discipline. So we're going to be filing 5 cases tomorrow, and I'll show you the different sizes of the petition. Of course, it goes without saying, it's not like you have a bigger petition that you're going to get approved, or if you have a smaller petition, you're going to get approved. It has no correlation. The idea is to tell a narrative, is to create and architect a narrative and to control that narrative. Just like when you watch a film or when you're reading a book, there's a narrative that has a specific beginning, middle, and end. And the goal for us is to be very persuasive with that narrative that we are creating. So instead of utilizing film to tell a story, we're utilizing legal principles, and we're utilizing the different forms of evidence and the regulatory criteria that the law allows us to argue. So thank you so much. I'm sorry that it's been going in and out. I haven't been live in a while, so those are technical difficulties that I will resolve as I go through the lives again. But I will be live tomorrow and for the next 12 days. And I love talking about artist visas. And if you have any other questions, anything specific, DM me. I'm happy to talk. If you want a consultation, you can go on our website, but I do not answer legal questions via DM or anything like that. I'm licensed. The rules of ethics are very strict in New York. So I can only give legal advice to a client or during a consultation. But talking about the law and talking about trends is something that I can absolutely do, and I love doing it. So we will continue to do this for the next 12 days. So thank you everybody for who is watching. Thank you for all the comments, and I will see you tomorrow. Bye everybody.